Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with One Hatley PC, where we truly are your partner in the divorce and estate planning process. This is our podcast, I Now Pronounce You Divorce, where each week we talk about issues that our clients are facing or issues that we've heard our clients facing and what we can do to try to help you through this arduous time. Today, I'm joined by Dan Cuneo, and this is part 2 of us talking about protective orders. Last week, we kind of covered what a protective order is, how people go about getting protective orders, and some of what rights can be subverted because of a protective order, right? Like if you are subject to a protective order, somebody got a protective order against you, what you can and can't do. And we very briefly started talking about if you have a protective order, what does that piece of paper actually do? And the answer was, well, I don't know. It wasn't that weak. It was, well, it protects you, but it doesn't stop somebody from doing a bad act. So, Dan, what sort of advice, when somebody goes and gets a protective order, do you give them any advice like, hey, this is what you should do next? You're dealing with a truly violent individual. This is my advice. What advice would that be?
Sure. And it depends on what the allegations are and what the parameters of the order of protection or the restraining order that's been entered. But I always advise do not reach out to the other side because that would just kind of subvert and really negate the whole issue, right? Because then it's putting into question your veracity to the court. So do not reach out to the other side. But then also, if the other side does reach out, don't respond. And then notify your attorney right away if you have one. If you don't have one, I would then notify the sheriff's office or the police because they're violating the protective order. More likely than not, there's going to be some type of provision that states that they cannot have any communication with you whatsoever through any type of medium. Now, there are extenuating circumstances, and the court has the authority to say, okay, if there's children involved, you communicate through My Family Wizard or other apps that are available, or you can only communicate via text. So there are potentially some ways that there could be communication. But at the end of the day, it's very limited if there is any. But I always advise do not communicate and just make sure that you're tracking everything that's happening. And then let others know if you have a parent that's surviving or a close friend, let them know about the order of protection. Just kind of check in with them just so they know that you're okay.
Yeah, absolutely. I'm not a big fan of airing your dirty laundry in divorce situations because sometimes that can come back and bite you. But when you're in situations regarding your safety of you and maybe your children, it is best to seek help. One of the things I always advise victims to do if they truly are afraid is to go to somebody else's house for a while. Let this cool down, right? If you can go to your parents' house for a week, if you can go to a friend's house for a week or two, just let this cool down. And I've had people completely move out of a house. The house is set there vacant because they're like, I don't want to be anywhere where this guy knows where I'm at. And you gave a really good piece of advice. And we see it more often than you would think is the person, the supposed victim, starts reaching back out to the person they said was abusive to them. And, when I've been in situations where I'm defending the person from the protective order, we'll just get a big batch of text messages where it's like, oh, I'm so sorry I did this. I love you. Like, I shouldn't have done this. The kids really want to see you. Will you come back over and see the kids? That's not good for your case, is it?
It's not. And it goes against everything you probably presented to the court on why you needed the order of protection.
Mm-hmm. And there are situations where the person actually did something. I've had clients be like, no, I did what was said I did. But then the other side starts feeling bad because they're like, well, I don't want them to go to jail. I don't want this. I don't want that. I don't want their job to be impacted.
Right.
And, if you're representing the person trying to get out from under the protective order, great. If you're representing the person that actually needs protection, not so good. So what do you do in situations where you have a client who tells you a story about something and you're not quite sure it rises to the level of a protective order or not? You're like, well, it could, it couldn't. Even from an objective point of view, I can't make my decision. What do you do in those situations?
Those are tough because sometimes clients don't know how to fully express themselves or the situation, or they're going through a situation that's just so tough that maybe they're not thinking of everything that has happened, and they're just so distraught or confused or upset. But I try to flush out with them and kind of walk me through what happened. Has this happened before? What did that look like? Were there any witnesses there? Was there any damage done? Was there any video that we can get access to? Was there, what does social media look like? Were there threatening text messages beforehand? And there's a lot of things that we can do. But if I'm still kind of questioning it and the other person is on the fence, then it's okay. Well, maybe we can enter into a consent order. And that way, neither one of you will disrupt or disturb the peace of the other, except for certain situations. And again, I always go back to they're very limited, but it's usually when there's kids involved. And then we get that signed by a judge, and then you have a valid order. So if it is violated, then you have remedies available to you. But at the end of the day, if the client's still not sure, and I may think, I don't know if it rises to that, but the client feels insecure and they feel threatened, those are usually what these types of orders are for. And so I would advise the client, if you really feel that your life is in danger or that there's some type of imminent harm, file that order of protection. I'd rather you take the more conservative way as opposed to potentially something happen. And again, especially if there's kids involved, we want to make sure that we're protecting our children, yourself too, but the kids, they're avenue protections through the parent. And so we just want to make sure that if there is any concern, we want to flush it out. As we mentioned in the other episode, maybe this is the time, if there are children involved, that we ask the court to order a guardian ad litem to be appointed. Or if there's another side, meaning another attorney represented, maybe both sides can come together and figure out, okay, this is what we need to do to try to remain peaceful and move forward throughout this process.
Yeah, I agree with that completely. What I tell people, in Virginia and DC, you can just go to the magistrate, right? If I'm not sure, I say, look, doesn't cost you anything. Go to the magistrate, tell the magistrate your story. If you can't get the protective order, no harm, no foul. The other side never knows about it. And now we've had an objective third person look at your facts, because the reality is, no matter how objective I try to be, I do believe my clients, right? I'm not perfectly objective person. I subjectively support my client. I'm hearing that story and I'm like, this is terrible. And I'm like, just go talk to the magistrate, and then if the magistrate doesn't agree, we've had a third party look at this and maybe we need to reevaluate the facts that are being said. It's an easy way around that. Kids are always a hot button issue. And, when you have children, I want to kind of look at this from the angle of somebody who's had a protective order put on them, right? So you have a protective order put on you. How important is it to fight for contact with the children?
It's very important, because at the end of the day, it's what's going to set the tone of how your case moves forward. If there's kids involved and the other side is trying to withhold them for whatever reason, and you just kind of allow that to happen, then you lose credibility with the court. And as lawyers, it really doesn't give us a lot of tools in our toolbox to use to show, well, wait a second, my client has been denied time and my client wants to spend time, but then the court may say, or the other side saying, well, wait a second, your client didn't ask to see the child or the children. Your client made no effort to communicate with them. Your client hasn't paid any type of form of support, and essentially has been off doing who knows what with whatever. And now all of a sudden you come back and you want to be part of their lives. It's very hard. And it just has so many ramifications, financial set aside. It's the children don't know who their other parent is, and it's not fair to the kids. Then they become even more of a victim throughout this process.
They do. I've had clients that come to me and they're like, look, man, I did what they said, right? Like, it was a bad night. I did what they said. I feel really bad about it. Just, I want to take the protective order and I want to go away, right? I don't want my kids to be around me right now and everything. And it's always a little bit weird when I have to advise the person, look, I know you feel guilty. Something bad happened. I get it, but we can't give up your rights to your children.
Right.
Conversely, if you are the victim of something, it becomes difficult, because then you're saying, look, this person has violent tendencies. I'm afraid for my safety, but yeah, go ahead and take the kids. Right. And that kind of cuts against the argument. So how do we reconcile that?
It all starts with having those frank discussions with the client. And when you were talking, it really resonated that if you did something or something close to what's being alleged, own up to it, get the help that you need, and then move on. A lot of courts will take that as a positive if you've identified, I either did it, I own it, it was a stupid mistake, it won't happen again, but here's what I'm doing, or that's not really what happened, but I could see what I did was wrong and I'm taking these steps to remedy the situation. That goes a long way in a judge's view, or even if there's a guardian ad litem appointed, it goes a long way in their view as far as, are you a threat to the children? But if you're the one that is filing it because of these issues, then it really depends on what those allegations are. Because if it's continuous harm to a child, then we want to get the other person in some type of therapy if they're willing, because hopefully we can get them better and get some type of reunification down the road. But until then, we want to put steps that are in place that secure the protection and safety of the kids.
Mm-hmm. Yeah, no, absolutely. It is tough because I've had clients come to me who are victims, and they're like, but yeah, the other side's really violent and they really did this and the kids saw it and it was really bad, but yeah, I still want them to be a parent. I'm like, how?
Right.
Like, I've got to ask the question at this point, like, how do you want them to be a parent? And how are we going to go look a judge in the eye and say, look, this other person's a terrible human, but we're letting the kids spend 3 or 4 days a week over there.
Mm-hmm.
And there are people like that. There's people like, well, if I'm safe, I'm fine. And in those particular cases, the court usually sees that attitude and fixes that problem. The other side of this is, you brought it up in the last episode, how much this can actually sway a divorce. If you get a protective order protection, some sort of restraining order where one party has to move out of the house, one party, has to take basically one bag of clothes, move out of the house, can't see the kids, can't come back around, has to have their whole life upended, it's going to give the other party a leg up in the divorce process.
Right.
How frequently do you see that these protective orders are being used for that purpose?
More often than not.
Hmm.
When the dust settles and the emotions are somewhat in check and the court has an opportunity to hear both sides, it's more of just a tactic to gain a short-term advantage. And at the end of the day, in my experience, the judges that I've been in front of can see that.
Hmm.
But also the client has to hire an attorney, and sometimes you don't have the financial resources to do so. But I always encourage, if you can, get a practitioner, a lawyer involved that can help you, because even though short term that's not going to benefit you, long term you're just going to have to wait it out. And unfortunately, those are tough discussions that I've had to have with clients, that this is a waiting game from the time that order was entered until the time that we have a court date. There's hardly anything that we can do. We can prepare your case, but there's hardly anything that we can do for you to see your child or your children. But that's why we have our day in court. Now, if the other side has an attorney, as we've been talking about, maybe you can reach out to them and come to some type of consent order, and then you dismiss the actual protective order, and then you can move on the case. But a lot of times I see the other side uses an advantage, because they say, okay, well, mom or dad hasn't seen the kids in this period of time, so now they're with me, so I might as well just be the custodial parent, because that's been the precedence. And courts place a lot of emphasis on what is the current situation, but sometimes their current situation is nefarious in the sense that it's because of this protective order that's entered. But for that, my client, mom or dad, would have been real involved in the kids' lives. And so now we have victims in the sense that my client's a victim because they haven't been able to spend quality time with their kids. But even more importantly, the kids are the true victims, because the other side is using them essentially as a pawn to gain some type of advantage, when at the end of the day, once the case progresses through the system, it will all get flushed out. But it takes a lot of patience and understanding on the client. But then on the attorney side, that's really where we come in, and we need to advise the client, this is what's happening, this is what we're going to do, kind of what are the next steps, so they know exactly what's going on, and why things are potentially happening, and what we're going to do to combat that.
Mm-hmm. Yeah, it's tough when it's being used for gamesmanship. But I always tell everybody, where one person's playing a game, it doesn't mean that we can't also participate in that game. And what I mean by that, I had a client who, before he hired us, he got a protective order because one night, while the marriage was falling apart, he got drunk and he's like, you know what, I should just go kill myself. It'd be easier. And wife went and got a protective order. It was pushed through in like the worst way possible. And the client didn't have an attorney the first time. Then he had an attorney, and everything was just pushed through the worst way possible. And by the time we got the case, it had been like a year. And mom literally just took advantage of a situation, right? And so what we did, we started sending letters almost weekly saying, look, he wants to see the children. He wants to see the children. And she kept having to say no. But the allegation was that he was just going to kill himself. That's it. No harm to the children, right? Let's be honest. I mean, if he kills himself, he's not hurting the children. And it was just one of those drunken, like, hey, it'd be easier if I did this. So by the time, and even the guardian ad litem at that particular point that we got the case was really on mom's side, being like, well, do you know how bad it'd be for these children if he did that? What a selfish person. By the time it got there, we had so many requests for him to just be able to talk to the kids on the phone on their birthday. And mom would say no. Talk to the kids on the phone for anything. Mom would say no. He asked if the kids could come to his birthday party. Mom would say no. Mom said no to everything. We got a complete switch in custody. Because we were able to take mom's game and show where this was just, and even the judge at that time of the divorce was like, this protective order should have never been entered. Because like you said, they'll eventually see through it. Even if it wasn't the first blush, right? They'll eventually see through it. What about the protective orders that come with any sort of criminal charges? Sometimes what we get is we'll get a protective order that it'll say like, look, the other side hit me, and then we'll get an assault charge. What about those types of cases? How do you handle those?
And there's a criminal aspect. I always ask the client to get a criminal attorney involved at the same time because I don't practice criminal law. I know enough to have conversations, but that's really about it. When your liberty is at stake, you don't want a family law attorney. You need a criminal law attorney.
Mm-hmm.
And we work in tandem because as a lot of times courts will bifurcate, meaning they'll separate the two issues. And what happens in one will have an effect in the other. And so you want to make sure that you're walking that line that protects the client both on the civil side, which is usually the protective order, and then on the criminal side, which would be the potential allegation of assault. And then that allegation, besides just criminal implications, if there's kids involved, then you're showing a potential propensity of being violent. And then under many statutes, and at least the states that I'm licensed in, that's one of many factors the court has to take into consideration when they're looking at awarding custody or even just looking at visitation. But then also you have the ancillary tangential issues that could come along with that, which would be employment. If you have that on your record, then you could potentially lose your job depending upon who you're working for or your clearance if you're in government, right? And so these things, it's hard to look more into the future, but they do have other ramifications. And so when there are criminal charges, I want to make sure that there's a criminal attorney involved on the other side and that we're working together because what he or she does on that side will affect how I handle this side, and how I handle the side will definitely affect how he or she handles it on the criminal side.
Yeah, and that's the best advice. I mean, I know that I used to do criminal in another life, and occasionally I love being able to jump in the criminal. One of the things I always warn people about is most jurisdictions, most states have some sort of first offender program. So you'll say, look, it's the first time, we'll have a reservation of a finding of guilt for 2 years, some sort of probationary period. And at the end of those 2 years, we'll come back and we'll dismiss the charges. But during those 2 years, you're in a probationary period. The terms of the protective order would stay in place, and you can't have any sort of violent contact. And what I have found, for first offenders, that's a great outcome if there's not a divorce involved. And so when you're going through the divorce and all of a sudden you can't have contact with the other side for 2 years and you've got to stay out of the house for 2 years, that's not tenable. And we have to say, look, we've got to fight these criminal charges. Yeah. And that's why it's so important, like you said, to have your criminal attorney working in concert with us so that we can point little things out like that, right? Like a criminal attorney, look, hey, first offender program is a great outcome. There's nothing on your record after 2 years. Just don't, if you didn't do it, it shouldn't be hard to continue not doing it. And it gets really, you're like, hey, yeah, that's a good point. But once that criminal bond is put in place, the conditions that is put in place, the court's protective order power goes away. The criminal case actually supersedes the protective order power. The court can't do anything. And I, unfortunately, have had the very unfortunate experience of having somebody come to us after a criminal attorney had convinced them of that, being like, okay, well, now I'm ready to do my divorce. And I'm like, don't bother hiring me, man. There's nothing I can do. The best I can do is advise you not to file. Let's just wait for 2 years.
Yeah.
So it's very tough. But Dan, I want to thank you for talking to us during part 2 of talking about protective orders. It's a very sensitive subject because there are people who are wrongfully accused and there are victims who are not getting the protection they need. So there's this issue on both sides that we talked about. And if you have been a victim of a crime, please go get a protective order. If you really didn't do it, please fight the protective order. That's how you start sussing out what is actually just in these types of cases. So if you or somebody is going through a situation like this, give us a call. Give Malone Hatley PC a call and see the difference that a partner can make for your case. If you have any questions, drop them in the comments. We love to answer questions and subscribe. So, each week you can kind of hear us talk about things that divorce attorneys consider interesting to talk about, and maybe it will help you through your time as well.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.